My name is Jeffrey Norris, and today we're going to be looking at consent decrees and how police agencies can avoid them. So in today's society, there are many ways that a criminal justice department may face liabilities. As we've learned in our legal aspects of policing class, this can come through false arrests, false imprisonments, excessive uses of force, racial bias in policing, and more. And it's very important that law enforcement officials know how to avoid liabilities and the negative legal actions that come from them. An example of an emerging form of liability within policing is the increased use of consent decrees. To better understand this creation, it's important to analyze what a consent decree is, and to then look at how criminal justice agencies can avoid them through community-oriented policing tactics, policy revision, and improved training methods. So the first thing we're going to look at is what is a consent decree. A consent decree is a court-ordered and court-enforceable settlement that can come against a criminal justice agency. Ultimately, it's a form of organizational liability because a whole agency receives it when that agency is found to be acting inappropriately and with patterns of misconduct. A consent decree cannot come against a single officer. A consent decree can't come against an agency if there is only one officer in the agency acting in liability in one instance. A consent decree is a legal action that comes against a whole department when there is consistent patterns of misconduct and liability within that department. Consent decrees were largely created by the Crime Bill of 1994, which allowed the U.S. Department of Justice to investigate criminal justice agencies around the country. And the DOJ is authorized to investigate an agency when there are patterns of misconduct and claims of civil rights violations that come against the agency. When the DOJ investigates these claims, the investigation can lead to the issuance of a consent decree if a department is found to be liable for the aforementioned malpractices. The decree is ultimately designed to end negative behaviors within a department by creating mandates that are aimed at promoting positive change and terminating inappropriate acts. And this will vary based on the liability a department is facing and on the department itself. Consent decrees may orchestrate improved training methods, better hiring procedures, more internal investigations into a department, diversity trainings, a culmination of all of these things, or more. But it's important to note that the whole point of a consent decree is to end patterns of misconduct in an agency. And to ensure the success of the guidelines of a consent decree, the decree is overseen by a federal judge, usually for a length of 5 years, so it lasts quite a long time. Currently, there are 14 police departments working under a consent decree, and that might not sound like a very big number, but when you think about it, it is. Like I said, a consent decree is not something that's brought against individual officers. It's something that comes against a whole agency. And to realize that there's not one, not two, but 14 police departments around the country that have acted with so much liability, with so many patterns of misconduct, with such egregious actions, that the federal government has been forced to come in and make these departments change, that really shows you how big and prevalent the issue of consent decrees is becoming, how big and prevalent this form of liability is becoming. And to further demonstrate this increasing prevalence, I want to look at some of the agencies on SEWR's list of organizations working under a consent decree. The Miami Police Department is under a consent decree that calls for improved use of force trainings and better internal investigations of officer shootings after the DOJ found the agency to be overzealous in its use of deadly force. What happened in this case is many officers of the Miami Police Department were involved in officer shootings in a very short amount of time. This seemed very odd, so the DOJ investigated it and found that the department was using inappropriate deadly force, and this led to a consent decree coming against the Miami Police Department. The Cleveland Police Department was found to be utilizing excessive force on criminal suspects, which led to them receiving a consent decree that required the increased use of community policing tactics and improved training on racial stereotyping and the mentally ill. So officers of the Cleveland Police Department were using excessive force, and this was really a result of them not understanding their local communities and not understanding people of different ethnicities and mental states. So to limit excessive force due to this lack of perspective, a consent decree was issued that really called for community policing, which helps with forming relationships and understanding communities, as well as diversity training. The Ferguson Police Department was found to be acting with consistent racial bias, which led to a consent decree creating a civilian review board aimed at holding police officers accountable. Now, I'm sure everyone knows of Ferguson because of the Michael Brown incident, but like I said, consent decrees don't come because of singular actions. The DOJ found patterns of racial bias within the department, which led to the consent decree. The New Orleans Police Department received a consent decree requiring policy revisions and the increased use of body and dash cameras after the DOJ found systemic problems within the agency. So here you see a consent decree being issued that really advocates police accountability through new technologies in law enforcement. Lastly, the Seattle Police Department was found to be overly physical with suspects and citizens, which led to them receiving a consent decree calling for improved officer training aimed at reducing the unnecessary use of force. And what I've listed is only 5 agencies currently working under a consent decree. Like I said, there are 14, and when you realize the gravity of these issues, it really shows how prevalent and severe this form of liability has become. And while the consent decrees may sound beneficial because they're promoting organizational change, ultimately they're a form of liability, which means that inappropriate behavior is present. You don't want a consent decree because it means that your department has been acting with such extreme patterns of misconduct that the federal government has had to come in and make you change. Additionally, it can be argued that consent decrees hurt agencies and local communities. For example, they increase federal powers by allowing the federal government to deal with local problems. And this might sound great, but this limits state power and it limits local communities and their voice and their power. And it reduces the principle of federalism. And this is not good because the federal government should not have their hands in too many things. And local communities and states better know what their constituents need and how their local criminal justice agencies should change. Consent decrees also reduce democracy by taking power and choice from local communities and distributing it to federal officials. Local constituents have a harder time promoting change under a consent decree because they can no longer go to a city council or a police chief and promote change. It's hard for them to go to federal officials that are not elected by them and that really don't care what a few local community members have to say. They're concerned about fulfilling federal mandates. Consent decrees may also reduce effective leadership by requiring supervisors to complete large amounts of paperwork and to adhere to federal mandates as opposed to implementing strategies they believe are effective. Supervisors are unable to lead how they want to lead because they have to follow the mandates of a consent decree. Lastly, consent decrees impose economic burdens on localities by requiring large operating expenses but not providing for the payment of these costs. Like I said, consent decrees usually last for about 5 years, and they cost millions of dollars each year. And if a community that has a very tight budget and that can hardly make the budget without a consent decree, if a consent decree comes against that community, they're going to be strapped economically and have a hard time meeting monetary needs. And due to these issues, it's very vital that criminal justice agencies avoid consent decrees. So the first way we're going to look at as far as how a criminal justice agency can avoid a consent decree is through community policing tactics. So what is community-oriented policing? Ultimately, it's a philosophy that advocates forming partnerships with local communities and using these partnerships and problem-solving techniques to address public safety issues such as crime and social disorder and organizational problems. Community policing is all about forming relationships with local communities, and it's through these relationships that police departments can learn of problems within their agencies and of potential areas of liability because community members have a better voice of pointing them out due to the relationship they have with the police department. And by having better knowledge of these potential areas of liability from community members, police departments are better equipped to deal with them. The three key components of community-oriented policing consist of police agencies forming partnerships with local communities, organizations making positive changes to deal with community and department needs, and agencies using problem-solving techniques to proactively address community and departmental issues. So the first aspect of community policing that we're going to look at is community partnerships. And this aspect of community policing involves forming relationships with various parts of the local community. You know, you don't just want to be serving your community, you want to be a part of it and you want to understand it. And by forming these relationships, criminal justice agencies are able to learn of problems because they have relationships with community members, which allows community members to have an increased voice and increased freedom to go to an agency and tell them of problems that they see within the agency. This relationship also results in community members being more likely to give aid to criminal justice agencies, and it also results in increased trust between local community members and criminal justice agencies. And it's important to note that these partnerships and relationships can be formed with all aspects of the community, and this can include individual community members, private businesses, media outlets, community groups, and more. And it's vital that criminal justice agencies form relationships with each part and each aspect of the community. You don't want to cater to one part of the community but not another, because every aspect of society has a specialized view on local issues. The media might have a certain view on growing crime rates, while local community members might have a more specialized view on liability within a police agency. It's important that law enforcement officials work with all of these individuals and groups so that they can garner public support from all of these groups and gain a comprehensive view of societal problems. Like I said, by catering to all of these groups, you get all of their specialized views and you learn of more of the problems and liabilities that may be facing your department. Additionally, it's important to note that everyday officers are crucial in the formation of these partnerships because they are the ones with whom the community interacts. They're the ones pulling people over. They're the ones that are in the fast food restaurants on their breaks. They're the ones that are going to the local grocery store to make sure that everything is okay, that shoplifting isn't happening, and things of that nature. They're the ones that are forming relationships with local communities. And due to their vital role, these officers receive increased decision-making powers when utilizing community policing tactics. Now, once a criminal justice organization forms relationships and learns of problems and societal views on issues, community policing takes things a step further and allows police departments to make positive changes that deal with these problems. So what happens is an agency forms a relationship with the community, and due to this community's increased voice, they can inform an agency of problems within the department or within the community itself, and then the department and supervisors can implement policies that deal with these problems. Now, since we're talking about organizational liability, what I'm going to talk about has to do more with that aspect of community policing. So, for example, community partnerships may reveal that there are issues relating to ineffective police leadership, reduced officer discretion, poor use of force policies, the abundance of a particular crime, and more. And it's important that supervisors recognize all those things because failing to address any of them can lead to patterns of misconduct and potential consent decrees. Community policing and organizational transformation allows a department to more easily recognize these issues through community relationships and implement change. And the last point, that change may entail improved supervisor trainings, new policies allowing for increased discretion in the proper utilization of force, and the development of strategies aimed at ending troublesome crimes, as all of these things deal with the issues and prevent patterns of misconduct and consent decrees coming from those patterns. Now, lastly, the last tenet of community-oriented policing involves problem-solving techniques. And community policing does not simply fix a problem in the short term through organizational transformation, but it seeks to prevent issues from happening in the first place. For example, an agency will not simply develop a strategy meant to deal with a certain crime, but that organization will look at the underlying causes of a crime to ensure that future policing techniques do not neglect to deal with that problem. An example that has to do more with the liabilities I'm talking about would be a department that learns that they have employed officers who abuse their authority. Community policing would go beyond simply disciplining these officers and would advocate improved hiring procedures aimed at recognizing those that may abuse power. It would go beyond simply slapping the officers on the wrist, and then 3 years down the road you have the same issue coming coming again, but it would create procedures and policies that would stop the inappropriate behavior from ever happening again by squelching the hiring of those problem employees. And this would be done, like I said, by improving hiring procedures. And these improved hiring procedures that are made through problem-solving techniques would prevent patterns of misconduct and consent decrees from arising in the future. So how does community policing prevent consent decrees? I've touched on it a little, but here we're going to go through it a little more in depth. To start off with, by forming community partnerships, agencies are able to learn of problems before they progress into patterns of misconduct and consent decrees. For example, officers within a department may utilize force based on racial bias. Community policing would give societal members a platform from which they could report this behavior, allowing supervisors to recognize and amend issues before they are substantial enough to warrant liability, DOJ investigations, and a possible consent decree. So by forming relationships with localities, police departments are able to clearly, efficiently, and quickly recognize and fix potential areas of liability because community members are better able to point out blind spots within an agency. Police supervisors do not have the resources or the time to micromanage every supervisor. Not every supervisor, but every employee. But when a department utilizes community policing techniques, community members have a relationship with departments, and this relationship gives them a better voice to voice concerns and to voice areas of liability that they note. And this increased voice allows them to go to supervisors and tell them about potential areas of liability they see rising. And this is often done before an area of liability grows to an astronomical size. And because of this increased voice, because of community members telling supervisors of these issues, supervisors are able to squelch issues and to stop issues and to deal with issues and potential areas of liability early in the process, as opposed to not being able to learn about them, and then you have to deal with the issue when it's developed into a pattern of misconduct and a consent decree. By giving community members increased relationships and increased voices, they have a better platform to really tell supervisors of issues and to allow supervisors to deal with these issues before they can really hurt a department. Also, by promoting lasting change through effective problem-solving techniques, community policing eliminates factors that may lead to future liabilities and consent decrees. Like I said, you're stopping an issue from ever coming again. For instance, an agency that is notified of ineffective supervisory leadership will do more than just improve manager training, but it will look at the specific factors and characteristics attributing to the ineffective leadership, and the agency will then implement policies that eliminate the hiring of individuals possessing those attributes. Community policing's problem-solving aspect would help to create this policy, which would reduce supervisor liabilities and patterns of behavior that could lead to consent decrees. So like I said, community policing helps departments recognize a problem, and then departments utilizing community policing tactics are not just going to stop the problem in the short term just to have it come up again 3 years down the road. They're going to prevent the problem from ever happening again. And this results in the reduced chance of patterns of misconduct coming years down the road, which results in reduced consent decrees. Lastly, by advocating for the increased role of everyday officers in decision-making and the life of a community, officers are able to improve personal relationships with the communities they serve. And this is great because, like we saw in the Cleveland Police Department, excessive force was being used because officers could not relate to their local constituents. Relationships that are formed in community policing lead to an increase in public trust and a reduction in police-citizen tensions and issues because officers and citizens understand each other. And this reduction in tensions and issues and this increase in trust leads away from patterns of liability and consent decrees that could come against a department. Now, the next thing we're going to look at that can help to prevent consent decrees is policy revision. What is policy revision? Ultimately, policy revision ensures that department policies are current in dealing with present issues within an agency. Policy revision is all about looking forward and creating mandates and structures that are meant to help officers in the present and future tasks, that are meant to help officers avoid patterns of misconduct in present and future tasks as opposed to relying on older mandates. It's important to note that departments that use policy revision must conduct job assessments, and these generally precede policy revision. And what the assessments do is they help supervisors recognize potential areas of liability within a department. They help supervisors recognize areas that officers may not be acting liably in, but there may be a chance that they could down the road. And once these areas are revealed, once these potential areas of trouble are revealed, policy revision allows an agency to institute guidelines that reduce liabilities and problems in troublesome areas. So you're recognizing potential areas of liability, and you're preventing liability, patterns of misconduct, and consent decrees from coming from these areas by implementing policies that are meant to reduce issues. For example, a job assessment may reveal that officers have an increased chance of making illegal arrests when dealing with individuals suspected of using illicit drugs. Policy revision would allow supervisors to take this information and create a policy that better outlines arrests based on probable cause and the factors needed for it. And this new policy would help to reduce patterns of liability within the department because officers would have a better understanding of legal actions they can take. So like I've been saying, policy revision would reduce liabilities in this case because it would allow officers to see this supervisors to see this potential area of liability before it grows, and then it would allow managers to create policies meant to reduce liabilities in this area, which goes on to reduce patterns of misconduct and future consent decrees. Lastly, to make policy revision truly effective, supervisors must enforce new guidelines that are created. It doesn't matter how great your policies are, if they're not enforced, people aren't going to follow them, and you're going to be open to liabilities. But by ensuring that officers follow new policies, by making sure that supervisors are enforcing them, supervisors protect their agency from liabilities, they keep staff members accountable, and they advocate guidelines that are meant to aid their employees and communities. So how does policy revision prevent consent decrees? Policy revision allows a police agency to avoid consent decrees by promoting the consistent creation of guidelines aimed at solving current issues within a department. The solving of these issues ensures that departments are avoiding patterns of misconduct and the consent decrees that follow them. Like I said, you're looking forward. You're looking at issues that may come against your department, and you're implementing policies that look forward to prevent patterns of misconduct and consent decrees from coming from those issues. Additionally, by advocating for the use of job assessments, policy revision ensures that police administrators are constantly aware of potential areas of liability within an agency. Like I said, supervisors don't have the resources to micromanage everyone, but job assessments really help them have a broad view of police work and of the jobs of officers, and it really helps them see areas where liabilities may arise. And by knowing of these areas, administrators can take proactive actions against them and prevent patterns of misconduct and consent decrees coming from those areas. And this is all done through the job assessment that accompanies policy revision. For example, officers within a particular agency may encounter many opportunities to utilize excessive force when dealing with intoxicated individuals. A job assessment would reveal this fact to supervisors, allowing them to create policies aimed at avoiding patterns of liability in these cases. The job assessment may reveal that officers, while they may not be acting liably, they have a great chance to act liably, and this liability could rise a week from now, a few months from now, a few years from now, whatever the case is. But the job assessment would reveal this potential area of liability and allow supervisors to take action against it before it grows to an astronomical size and before it leads to patterns of misconduct and consent decrees. On the other hand, a department that does not utilize policy revisions and job assessments would have a harder time recognizing this because it's a potential area of liability, so liabilities aren't rising yet, but they're getting close to rising. And when the issue does rise, administrators would be taken by surprise because they are not using job assessments, and it might be too late at that point, and the issue could have led to patterns of excessive force, DOJ investigations, and consent decrees. Finally, by requiring that supervisors enforce new guidelines, policy revision really requires police managers to be involved in the lives of their staff members, and this increased involvement allows supervisors to better note patterns of inappropriate behavior in officers that do not adhere to beneficial policies. So supervisors are getting involved in the life of their department, and they're really seeing the officers that are all about following guidelines and all about avoiding liabilities, and they're seeing the officers that are ignoring new guidelines, and that could open up a department to patterns of misconduct and consent decrees. And by being able to recognize these tendencies in these officers, supervisors are better equipped to deal with misconduct and advocate guidelines that deter liabilities and consent decrees. They're better equipped to recognize problem officers, to recognize officers that could lead a department into patterns of misconduct, and they can take actions against these individuals before the patterns of misconduct lead to consent decrees. So it's clear that the creation and enforcement of strong policies promotes professionalism in policing, which helps to reduce opportunities for liability. So the last thing we're going to look at is improved training methods. What is improved training? It involves adequately training officers in areas where they may encounter potential liabilities so that they can avoid these negative actions. So whereas policy revision recognized potential areas of liability and created policies to avoid liabilities and consent decrees in these areas, improved training methods involves recognizing potential areas of liability and improving training methods to prevent liabilities and consent decrees in these areas. For example, a department that utilizes improved training methods will recognize that officers encounter chances to utilize excessive force and inappropriate deadly force, leading that agency to consistently train officers on the appropriate use of force and on new laws regulating such actions. Like I said, improved training looks at areas where liability may arise and implements innovative training procedures to deter patterns of misconduct and potential consent decrees in those areas. It's also important to note that agencies that use improved training methods continually look for innovative, better ways of training their officers, and this, coupled with the fact that these organizations look to train officers on specific actions that can lead to liability, helps a department to avoid patterns of misconduct and potential consent decrees. So departments that use improved training techniques aren't looking to use the same technique for 10 years. They're looking to find new ways to train officers. They're looking to find ways to train officers that really decrease the chance of liability, patterns of misconduct, and consent decrees, and they're utilizing these methods to decrease those negative actions. Additionally, agencies that utilize improved training methods go beyond simply teaching about the technical aspects of policing. They go past simply teaching about firearms training or how to take down a suspect or how to arrest someone, and they train officers on how to relate to diverse individuals. And this can be people of different age, race, mental state, social class, whatever you can think of. And this is vital because officers are going to encounter these people in many different situations. And they have to be able to relate to them. They have to have diversity training to relate to them so that they can better understand their perspectives, as understanding someone's perspective reduces the chances of you acting with excessive force towards them or you acting with racial bias towards them, and it reduces the chances of you acting liably toward them. Departments that use improved training methods also make a large point of instructing officers on how to de-escalate situations, as opposed to briefly talking about the subject before going on to primarily focus on the use of force. And this diversity and de-escalation training allows officers to better understand the viewpoints of citizens and avoid actions such as the excessive use of force that could potentially lead to patterns of liability and consent decrees. So what you're seeing is that agencies that use improved training methods go beyond really traditional police training, and they look to help officers see that force is not always needed. It should only be used when it's absolutely necessary. That's something that's constantly talked about within policing, but is it something that's really advocated in training? I would say no. Improved training departments also seek to teach officers how to relate to others' perspectives, and the combination of these two things prevents patterns of misconduct and consent decrees. Lastly, departments that utilize improved training methods make sure that they consistently train supervisors, and supervisors are really responsible for many things in a department. They have to know how to note changing laws, they have to be able to effectively implement new policies, they have to know how to improve training programs, they have to know how to discipline troublesome officers and how to note potential areas of liability in a department. They have to be able to properly evaluate new hires and much more. And a failure to do any of these things can lead to patterns of liability within an agency. Supervisor training ensures that criminal justice managers understand how to perform these tasks and that they are able to properly identify troublesome areas within an agency. And this really creates managers who know how to positively train staff members and who are capable of leading agencies away from patterns of liability and consent decrees. So how do improved training methods prevent consent decrees? I've touched on it a little, but I'm going to go a little more in depth. Improved training methods prevent consent decrees by taking a proactive approach to avoiding patterns of liability. This is because supervisors recognize areas of liability and implement innovative training before legal action comes against the department, as opposed to simply training officers after an individual makes a claim against an agency. Like I said, you're recognizing a potential area of liability, and even though officers may not be acting liable in those cases, you're recognizing that there's a very high likelihood that they eventually will. And because of this, you're taking action to implement positive, innovative, new training procedures that limit patterns of liability in these areas and limit potential consent decrees in these situations. You're attacking the problem before it attacks you. Additionally, it's been noted by many sources that police agencies often do not spend enough time instructing officers on citizen diversity and how to avoid the use of force, and this is very negative because officers don't understand the perspective of others, which can lead to excessive force and racial bias in policing, which can lead to patterns of misconduct and consent decrees. Agencies that implement improved training methods avoid these negative patterns, avoid these consent decrees by spending large amounts of time teaching officers about public diversity and how to avoid the use of force when interacting with the public. Like I said, you're going past the traditional police training program and you're teaching officers additional ways on how they can avoid consent decrees and liabilities. An example of agencies using this improved training method and really avoiding liabilities can be seen in the Richmond, California Police Department, where in 2008 they began to implement a program that trained officers on how to avoid the use of force. Since that training, officer-involved shootings have occurred less than once a year, with the first fatal shooting occurring in 2014, a full 6 years after the training was implemented. So here you see de-escalation training really reducing behaviors that could lead to potential liabilities, that could lead to patterns of misconduct and consent decrees. Adding to this, the Seattle Police Department recognized that its officers and supervisors were treating citizens and employees with bias based on race. And this led the agency to create a bias-free policing course that has helped to reduce employee bias within the department. So here, you see an agency using improved training methods. They recognize a potential area of liability and they attack it head on, which leads to the reduction of liability, which leads to a reduced chance of patterns of misconduct and consent decrees. So it's very clear that improved training on the use of force and diversity has prevented situations that could lead to patterns of liability and potential consent decrees. Lastly, many departments may be found liable because supervisors do not adequately train employees, and this can come from claims of failures to train where supervisors are not, like I said, adequately training employees, or in situations where supervisors don't address patterns of inappropriate behaviors, which can go on to lead to consent decrees. Agencies that utilize improved training methods, however, avoid these consent decrees because their supervisors also receive instruction. Managers in these departments cannot be found liable for failures to train because they are constantly instructed on how to properly train their employees. And by putting this instruction into action, supervisors are able to avoid liabilities and consent decrees that may arise from failing to train employees. So supervisors in these departments, they're learning how to train employees and they're training these staff members. And this avoids patterns of misconduct coming from failures to train, and the increased training of staff members avoids patterns of misconduct that could come from failures to train in their case, and this leads to a reduced chance of consent decrees. Also, training supervisors helps to avoid consent decrees because managers are taught how to recognize changing laws in areas in which employees need instruction, such as search and seizure guidelines, the proper use of force, verbal skills, and more. It's very important for a police supervisor to understand changing laws, as a failure to do this can lead to liabilities. Laws sometimes change overnight. Let's say there's an example where case law changes and there's different structures on excessive force. If a supervisor doesn't know how to recognize this, there could be a whole agency acting in excessive force because the supervisor did not know changing law and did not tell this to his subordinates, leading to them acting against the case law, acting with patterns of misconduct, which could lead to a consent decree.
But by being able to learn of how laws change and ways in which employees need instruction, supervisors are better equipped to train employees on proper conduct, and they are better able to give staff members information that will help the department avoid patterns of liability and consent decrees. So, in conclusion, after we looked at what consent decrees are and the ways you can avoid them, it's very clear that consent decrees are a growing form of liability, which is used against criminal justice agencies exhibiting patterns of misconduct and inappropriate behaviors. It's very important that departments avoid these behaviors and the consent decrees that follow by making use of community-oriented policing, beneficial policy revisions, and improved training methods. Law enforcement practitioners must study these creations so they can prevent consent decrees and better serve their local communities. And here you will see my reference list. I highly recommend looking at all of them. They all had a lot of really interesting, beneficial information. I thank you for your time, and I hope that you enjoyed the presentation and that you have a great rest